Hey, Chalk and Gavel listeners, welcome back to the show. Just a few quick announcements before we get started. First, please take a few moments and rate and review Chalk and Gavel on your favorite podcast platform. Also, go to chalkandgavel.com and we have a feedback form you can fill out and let us know what you think about the show.
We'd love to hear from you. We'd also be incredibly grateful if you'd consider supporting us on our Patreon page for just $2 a month. You can help us sustain the show and keep delivering the education law content you've come to expect.
Okay, you ready to dive into this thing?
Let's do it. When are schools legally responsible for student injuries during athletic activities? Where is the line between a creative drill and an unnecessary risk? Was the school out of bounds? It's no slam dunk, but these cases might have you crying foul. That was so dumb.
That was great. All right. We've got a twofer in today's episode, everybody. 2 cases for the price of 1.
Free.
For free. We're covering another negligence topic today, folks. So we did a negligence case a while ago about the unsafe use of scalpels in a science class. But today we're heading down to the athletic department to talk about 2 cases where sports practice resulted in students getting injured. From a basketball drill gone wrong to an errant baseball throw, what happens when a school allegedly drops the ball with school safety? Yeah, you like what I did there?
Uh-huh.
These are the cases of Secky versus New Paltz Central School District and Grady versus Chenango Valley Central School District. I don't know if I said that right, but we're going to just go with it.
Let's do it.
All right, game on.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, Chris, what's our bell ringer today?
Yeah, so I've got an update for you on Louisiana's recent law that we talked about a few episodes ago that requires schools to post the 10 Commandments in every classroom. So we talked about this before, but on November 11th, we've got a new update. A U.S. District Court judge issued a preliminary injunction preventing the law from going into effect.
Oh, wow, really?
Yep, so it is on pause. And that was pretty much what we expected, right? Because there's that 1980 case, Stone versus Graham, that essentially ruled in very similar situation that posting the 10 Commandments or requiring schools to post the 10 Commandments violated the Establishment Clause.
Right.
So this is not really that much of a surprise.
No, that's not really that much of a surprise. You know, it might be a surprise if this thing ever gets to the Supreme Court.
Well, and that's kind of that seems to be the strategy here, right? Because Stone versus Graham, 1980 case, it applied the Lemon test.
Which has been kind of kicked to the curb.
Yeah, by the Supreme Court in Kennedy versus Bremerton. So like we've got this legal precedent that seems to be on shaky grounds because we've kind of changed the standard. And so that's 100% what Louisiana is doing here, because as soon as this decision came down, the court said, like, you know, look, this law likely violates the Establishment Clause. It favors one religion over another. It also interferes with the rights of people to practice their religion without governmental interference. All of that is like a slam dunk Establishment Clause under existing law. But Louisiana said immediately, like, we're going to appeal this And so it seems like they're teeing this up to get to the Supreme Court. But at least until then, this injunction will likely stay into effect, obviously depending on what the appellate court does. But the law will not go into effect right now, at least.
Right. If you tune in to our New Year's Eve episode, one of the shows that we recorded when we were at the Education Law Association, we talked about this 10 Commandments law in what we think was kind of a funny way. We highlighted a lot of the ways that teachers were thinking about being compliant with the law.
Some creative compliance, right?
Yes, exactly.
Yeah, you have to post them. It doesn't say exactly how you post them or what you post them with.
So, but even though now you don't have to post them,
now you don't have to post them.
That's what this ruling is about. You're still going to want to listen to that episode that we recorded at ELA, which will come out on New Year's Eve. Right.
Not your typical ed law update.
Yeah, I think we're going to have some visuals with that one too. So, so that's really cool, Chris. Thank you for sharing that. All right, you ready for today's episode?
Absolutely.
All right, yeah. So like we said, this is a buy one, get one free episode. Well, buy both of them. None of them cost you anything.
Get one free, get two free. Yeah.
So today we've got 2 episodes wrapped in one, and we're doing that because these cases were consolidated on appeal all the way up at the highest court in New York, which is not called the Supreme Court. It's called something else. We'll talk about that later.
It's so confusing.
It's very confusing. We might not even bother talking about it because it's like, who cares? But we'll mention it because we're here to educate.
Exactly. And entertain, or try to.
But real quick first, Chris, how does a case get consolidated with another case? Who makes that decision?
Yeah, so consolidated cases are basically just cases that have both been appealed to a court, and the court kind of looks at them and says, these have the same question of law. Mm-hmm. They might have different facts, but because they've got a same question of law, it just kind of makes sense to decide them together. And so here, both of these cases have the same question of law about whether or not this doctrine of assumption of risk applies and how it applies to these situations. So they basically have the same question.
Yeah. Okay. And then the court is the one that says, we're going to combine these two.
Right.
Okay. All right, cool. So like Chris just said, we've got these 2 cases, and the big question is whether or not these schools were legally responsible for the injuries that were caused during sports practice, and whether that sort of assumption of risk that takes place when you sign on to play a sport. You're like, okay, you could possibly get hurt playing that sport, right? Like, where does the negligence lie? Where does the liability lie, right?
Right.
And so both of these cases, obviously, like we said, involve a student athlete in high school. Both of these are high school cases, and they were both during practices, not during games. One was basketball, one was baseball, and a student was injured in both cases. So we're going to tell you about those injuries, and we're going to tell you about how the court wrestled with who actually was at fault.
None of these happened during wrestling practice.
No. But we do. So how did the court wrestle with? I say that a lot. So the first case we'll talk about, this is Secky versus New Paltz Central School District. And this starts out in January of 2017. So JKS was a 14-year-old student on the junior varsity basketball team. We'll just call them JK, not short for just kidding, or Jamie Cudlitz, actually.
Oh, hey.
It was not me.
Were you 14 in 2017 in New York?
I was not. I was far from it, geographically and chronologically.
But maybe not in spirit.
No. And my sense of humor, too, is probably very similar to a 14-year-old boy's sense of humor.
I feel like that's just what happens when you're a teacher for long enough.
All right. So here we go. We got JK in January of 2017, a 14-year-old student on the junior varsity basketball team. And according to these court documents, JK had been playing basketball since he was in 3rd grade. He had probably been playing for 5 years or so. At that point, they claimed that basketball was a huge part of his life. He testified that he had played year-round. He would play 4 or 5 times a week. He was into it.
Yeah.
Right?
Very into it, sounds like.
So one day, the basketball team was practicing in the gym. We don't know very much about the gym other than it had retractable bleachers, which is very standard in a lot of gyms.
Yeah.
Okay. Those are those bleachers that, they come out, and they probably come out right close to the edge of the court, but when they're not in use, they can kind of fold up against the wall, right?
Right.
So we know that during this practice, the bleachers were retracted up against the wall.
Okay.
All right.
Don't want anyone tripping over them.
I guess. The coach, name is Coach Kenny, instructed the team to perform a 2-on-2 rebounding drill. The drill required the players to use the entire court without paying attention to the sidelines and end lines that are normally used for regulation basketball play.
Okay. So they're basically just ignoring out of bounds.
Yeah. They're basically like, you've got the run of the entire gym here. Okay.
Got it. Which I'm glad they pushed the bleachers back.
Yeah. Coach Kenny also said that he would call, quote, only major fouls. So I guess what would be considered a minor foul in normal gameplay is perfectly acceptable to Coach Kenny in this practice scenario. All right.
Okay. Sounds like he wants his kids to really kind of fight for these rebounds and be aggressive.
That sounds good to me. I don't know much about.
I was going to say, I've been avoiding asking you what sports you played because I don't want to answer that either.
No, not many. Not many.
I know the rules for all the sports.
I know some, and I can be entertained by a handful of sports. And after living in Chapel Hill for a long time, I became, I can watch a basketball game. Anyway.
Basketball's the one that I know the least about because I never played it. Like
I didn't say I know a lot about it. I can be entertained watching one.
I got you. Okay.
And I can kind of follow it.
All right. Well, you take point on this one. I'll take point on baseball.
Sorry in advance, audience.
We're doing our best.
Yeah. So one of the important things to note here is that JK recalled that performing this particular drill had not been done before. At least he did not recall ever doing this drill before.
Okay.
So this was potentially the first time.
Got it. Okay.
All right. So after the coach explained the rules, apparently nobody had any questions and they got started. JK watched for 2 or 3 other rounds of play before it was his turn to do the drill. And when he was up, apparently what happened was he went out of bounds. He took a pass from a teammate. He turned to go back towards the court and he was struck from behind by another player. Okay?
Which is probably just a minor foul.
Maybe. I don't know how.
Yeah, we don't know.
We don't know. Also, we don't know how hard the striking was.
It was apparently hard enough.
But it was hard, because it was hard enough to propel his right shoulder into the bleachers that were retracted up against the wall, and it injured him.
Okay.
Now, we don't know much about that injury. What we do know, though, it was enough to cause a lawsuit.
Well, yeah, I mean, we're talking about it, right?
Exactly. So the last thing that I'll say about this case, and this may give away some of what you're going to talk about, Chris, there was one more thing that we found interesting about the facts here. The case mentions 2 expert witnesses, one for the school and one for the basketball player. You can probably guess where this is going, but one expert witness thought that the school was in good shape, and the other expert witness thought that the school was not in good shape.
Right. Yeah, that often happens with these expert witnesses. You'll have kind of the dueling experts.
Yeah.
But expert witnesses are kind of there to help the court navigate really technical questions that the court just doesn't have expertise on. And so here, the court knows probably about as much about basketball as we do, right?
They probably know more.
Huh? But somebody's got to teach the court, hey, this is a totally normal thing that everyone does, or hey, this was really weird and kind of unsafe.
Right. So the school's expert was somebody named Coach Fruscio, Fruscio, who had been coaching since 1992. He had been inducted into the Upstate New York Basketball Hall of Fame, both as a player and as a coach, and who had, quote, numerous other achievements in the sport of basketball, unquote.
Wow.
So he claimed that the rebounding drill was reasonable and appropriate, that it was a drill routinely conducted throughout the state, and that it complied with accepted New York state safety guidelines. That's interesting, huh?
Okay. All right. So they've got a local expert kind of saying, hey, this was pretty typical.
Yeah.
Everyone does it.
Yeah. On the other hand, the plaintiff's expert, the JK's expert, and this probably surprises no one, did not think that the drill was safe or appropriate.
Yeah, because if he thought otherwise, JK probably wouldn't have hired him.
Exactly. So this expert was a consultant from Florida who had taught elementary PE for 33 years.
It's been a minute since we've talked about Florida.
Yeah, but it's time. It's time to bring it back. We're bringing Florida back, people. The student's expert was a consultant from Florida who had taught elementary PE for 33 years, had coached high school cross country and track, taught a college course on risk management and safety, which I thought was pretty interesting, and had played junior varsity basketball while in high school. So
yeah, the teaching the college course, I think, is the main point there, because he doesn't seem to have the same kind of practical experience as the other expert.
No, I mean, he's got some.
Yeah.
Like he has coached some high school sports, not basketball.
Right.
He's played high school basketball.
At the junior varsity level.
Right. But he hasn't coached it, and he was an elementary PE teacher.
Right.
So, I mean, I wouldn't say that the person has no experience. The person has a lot of experience.
Right.
It's just a little bit different experience.
Right.
And so he came to the gym. He took a bunch of measurements and pictures, and he said that in his professional opinion, it was unsafe for the coach to remove the boundary lines and permit reach-in fouls.
Okay. So making it so that they can play out of bounds, which puts them closer to things like these retractable bleachers, and to permit some fouls, meaning that, there's going to be a little bit more physicality, a little bit more contact.
Yeah. And so, I guess basically what he's saying is you're taking away a lot of the restraints or guardrails, right? That are there, whether they're there for game purposes or risk management purposes or whatever. Those are the guardrails that people get used to, right? When they're playing these things.
Yeah. And it's also how the guardrails are kind of the things you use to structure the game and the physical environment, right?
That's what I'm saying, right?
Yeah,
This is what people get used to when they're doing this, right?
Yeah.
So, and you're taking those away. So I guess that's what he's saying is taking all of those kinds of things away makes this inherently a less safe situation.
Yeah. So you've got your dueling experts then.
Yeah. Okay. So that was the first case. Let's talk a little bit about the second case. Let's pivot over to baseball.
Oh, good.
So this second case, this is Grady versus Chenango Valley Central School District. In this case, we've got somebody named Kevin Grady, who's a high school senior and a member of that school's boys varsity baseball team. Okay. And like JK, Grady had been playing baseball for a number of years. By his junior year, he had worked his way up to the varsity team. And so this was his second year on varsity baseball. All right. At the beginning of the season, Grady signed, like most athletes do, a duty to warn form, which is that it's a very typical form that just has a player acknowledge that in very general terms, that there are risks associated with playing these sports, and there could be some possible injuries that result from playing those sports.
Right. Yeah, that's a very typical thing that a lot of districts will do.
Yeah. And so, I mean, anybody who has, a parent who has played sports, anybody who is, is a parent who's had their kid participate in any sort of, almost any activity that involves any kind of physicality.
Oh, even field trips, right? Like you have to sign these forms before field trips.
Yeah. So this shouldn't be foreign to many of you out there.
Yeah. I've written many of these forms.
As have I. Absolutely. Okay. So here's what happened with Grady. So one day at practice, the varsity and junior varsity teams were practicing together doing an infield drill that they referred to as the warrior drill, which I think is the school's mascot.
Okay.
A warrior, not a drill.
Actually, the Chenango drills has a really fun ring to it, though.
Doesn't?
Okay. Yeah, because warrior drill, I read that and I was like,
I have a visual that's like a cartoon drill with like a battle axe and it's little drill cartoon hands. It's the warrior drill.
Yeah. Yeah.
Right?
No, I'm here for it.
You with me?
Yeah, no, I love it.
You're probably the only one who's with me right now. Everybody else has turned this off.
I mean, it makes more sense than a lot of mascots. I went to Ohio State and our mascot was a poisonous nut. So
what?
Buckeye, it's a nut. It's a tree nut.
Is that what it is?
But it's poisonous. Yeah. Yeah, see, no one even knows.
Really?
Yeah.
I mean, I've always known it was the Buckeyes, but like I've never even given a thought to like, what is that?
Yeah.
It's a poisonous nut?
It's a poisonous nut.
Oh, well, that's funny.
Yeah.
Okay, let's get back to this thing. Okay, so we've got this infield drill going on, and I guess what this drill was about was it involved multiple baseballs being thrown around all at the same time, which sounds very chaotic to me.
Right. Usually
Okay.
in baseball, there's only one ball.
Yes. That I know. I would be very surprised if I was watching a baseball game and I saw two balls going around at once. I'd be like,
Yeah.
this is not right.
Most sports only use one.
Pool,
Yeah.
billiards. Yeah.
Yeah.
That's a multiple ball
Bowling,
sport
everyone kind of has their own, but there's only one ball at a time.
at a time. Yeah.
Yeah.
All right. Well, that's for another podcast.
Yeah.
But unlike the JK situation, apparently this was a very common drill, and Grady was familiar with it, said that he had participated in that drill in previous years.
Okay.
So here's exactly what happens in this drill. It involves two coaches hitting balls to different players at the same time. So one coach would hit a ball to the third baseman, who would throw it to first base. The other coach would hit a ball to shortstop, who would then throw it to the second baseman, who would then throw it to the first baseman. But there were two first basemen, right? There was a first baseman for the first part of the drill, right? And there was a first baseman that was playing in slightly different position to catch the second baseman's throw, right?
Got it. Okay.
One first baseman was catching the throw from the third baseman, and the other first baseman was catching a throw from the second baseman.
This just sounds like a terrible setup to who's on first.
Right?
So basically, gist of it, there's two coaches hitting the ball to two different players. Those two players are throwing the ball around the infield to a traditional first baseman and then to another first baseman, the short first baseman who's like standing a couple feet away.
Yeah. Two first basemen who are catching balls. And there was a 7-foot by 7-foot screen between those two first basemen, maybe as a way to distinguish between the two and potentially protect. I don't know. I don't know exactly which direction the screen was facing and, how it was positioned.
Yeah, I guess the screen would be on the first base to second base baseline because that's where the throw is coming in for the short first baseman.
I would think so.
Yeah. But then
or maybe it's angled a little differently so that it's more towards the third.
I'm going to have to get a protractor and my angle out because these angles are not making sense to me. But that's it.
Yeah.
But I think that probably just goes to show this is a complicated drill. Anytime people are chucking baseballs around, it's not, there's always a chance that someone's going to be hit by it. But this sounds unnecessarily complicated.
It does. So in this scenario, Grady was playing the traditional first base position. So he was required to catch the balls being thrown by the third baseman.
Okay.
And during practice, and the balls were being hit and thrown around, at some point, an errant throw sailed over the screen and struck Grady in the head, fracturing his skull around the eye socket.
Oh, no.
Yes. After that incident, unfortunately, Grady lost most of his vision in his right eye.
Oh, wow.
Yeah.
Okay.
So this was a bad injury.
Very serious, right?
Yeah.
Okay, so it was the throw that was supposed to go to the short first baseman, goes past the screen, which was set up to divide or protect maybe, and strikes Grady. Oh, wow.
Yeah. And so we're going to, we'll switch over to the gavel side right now. But the one last thing that I want to say, my biggest takeaways when I was reading this before I even got to the gavel side here, when I was reading through this, was the similarity in these two cases. Not only is the question that the court was wrestling with sort of the same question, but the similarity to me, the thing that jumped out to me is you've got two practices occurring where things are happening that are incredibly non-traditional, or at least so unrelated to traditional gameplay.
Right.
That if you're playing baseball, you are not dealing with multiple balls.
Right.
You've got your eye on one ball,
right,
at any given point in time.
Yeah,
on the ball.
Yeah.
And granted, I know that, practices are supposed to enhance skill and really allow people to practice, and doing things outside of sort of normal regulation, restrictions, and play is a normal part of what practices are like. But it just sounds to me like this is a potential lawsuit waiting to happen. And guess what? It happened.
Yeah.
Let's talk about what happened in the court.
Yeah. So if we're talking about it, somebody filed a lawsuit. So both JK and Grady file lawsuits against their school districts. These are filed in New York State court because this is based on state law. And they claim that the coaches were negligent for how they handled things in practice and that negligence led to their injuries.
Okay.
So Jimmy, you mentioned it earlier. We talked about negligence in episode 13. That was tort liability and scalpels. But just to kind of reiterate, so negligence is a tort. Jamie, do you want to make your tort joke?
Yeah, it's not the kind you eat.
So torts are a category of civil wrongs. So this is civil, not criminal. Civil wrongs that cause harm or loss to another person that the person committing the act is legally liable for. So basically, that's just a fancy way of saying that a tort is a legally recognized civil wrong.
Okay.
So, Jamie, do you remember the elements of negligence from episode 13?
Yeah, they're the LMNOPs or the ABCDs.
DBCDs?
DBCDs.
Yes.
That's right.
See, that's the beauty of a good, and by that I mean terrible, mnemonic device.
Mnemonic device?
Yeah. So we've got duty, breach, causation, damages. So duty requires that you act with reasonable care towards others. That's kind of the traditional formulation of a duty. Basically, like you just have to be reasonable toward each other so that we don't accidentally hurt each other.
Okay.
Breach means you didn't act with reasonable care. So you did something that breached that duty.
Yep.
Causation means that your breach, not doing what you were supposed to do caused
the injury.
That injury was foreseeable. So something that you should have foreseen happening based on what you were doing. And then damages, obviously that's pretty self-explanatory. Somebody was injured because of all of this.
Okay.
So applying that to JK and Grady, looking at this like duty, check. We know that one's clear cut. Coaches usually have a duty of care towards their student athletes. We talked about duties for educators in episode 13 too, but typically they involve taking reasonable precautions to provide a safe environment, providing reasonable or proper instruction, and providing appropriate supervision.
Okay.
So here, those are all the duties that these coaches owed to these students. Breach is a little, I don't know.
Yeah. Did they fail in that duty?
Right.
That's a harder question to answer, right?
And that's usually kind of where a lot of these tort cases will fall was there a breach? So for JK, we kind of already talked about this in regards to the experts, but removing the boundary lines and allowing some fouls, maybe that crosses the line. Obviously the school is arguing that there was no breach because that's what their expert said. And the student is saying, yes, there was a breach. My expert says so too.
Okay.
For Grady, I think it's a much closer question, right? Because there was the 7-foot by 7-foot net.
But was that enough to mitigate the potential risk, right?
The potential risk of having multiple balls, which is by itself kind of a weird thing in baseball.
Right.
All coming from different places in the infield to one place on the field. So typically if you have a lot of, if you're doing a practice and there's lots of people doing lots of different things, they're doing
separated,
it in their own,
right?
Exactly.
You've got the outfielders tossing stuff to themselves and other things happening in the infield separately.
So everyone's not throwing the ball at one place. So breach, that's kind of one of those questions that we're going to have to deal with. Causation, again, that kind of just looks at whether or not the injuries were foreseeable and if there were any kind of intervening factors that would make it so that the coaches weren't responsible. And here that's kind of interesting because the injuries were caused by other players, right?
Not by the coaches themselves.
Not by the coach, right? But the coaches are the ones who created the drill.
Yeah. And isn't that generally how all this goes? Like when students play football or baseball or whatever, this risk document that they sign, what is implied there is you can get hurt in the course of gameplay, which is generally not involving the coach. Right. The coach is off to the side.
But these are lawsuits against the coach and the school. They're not lawsuits against the other student athletes.
Right.
Right. So basically, in that case, like the school or the coach has to be the responsible party.
Right.
And here, I think like in law, we call this the but-for cause. But for the coach setting the drills, the injury wouldn't have happened, right? So like the coach is the one who set the drills, who set the parameters in which the other athletes.
Right. And should have the expertise to be able to foresee potential issues with whatever practice scenario they're setting up.
Yeah. Yeah. So the causation is probably satisfied here. Just wanted to kind of raise that element of intervening factors.
Right.
And then damages is pretty obvious, right? Like we know that these students were injured. So the students are looking pretty good on their prima facie case of negligence.
Based on breach and causation and damages.
But that's not all, folks.
Of course it isn't.
No, it never is. Even if you state a claim for negligence, there are still potential affirmative defenses.
So what's an affirmative defense?
Well, one affirmative defense would be assumption of risk.
Okay.
Basically saying, hey, you knew about it. It was a known risk to you and you voluntarily did it anyway. So therefore, it's not my fault that you got hurt. It's on you.
Is that what it's saying? Or is it just more saying like, it's not our fault you got hurt, but you knew that you could potentially get hurt? It's not necessarily your fault, but you knew.
You're right. It's not saying it's your fault you got hurt.
Yeah.
It's you knew this was dangerous and you did it anyway. So therefore, it's not our fault that you got hurt.
Right. Because we told you. You could get hurt.
Or it was obvious based on the fact that you're playing a sport and things happen.
Gotcha.
I appreciate the distinction. So that assumption of risk is kind of the big legal question here for these cases. So as these two cases are kind of working their way through the courts, both schools file motions for summary judgment, arguing that they are entitled to judgment as a matter of law because of the defense of primary assumption of risk. The phrase primary assumption of risk is basically just like the phrase that New York uses for injuries that happen during athletic activities. They just call it primary assumption of risk as a different flavor of assumption of risk.
Okay.
And so at the trial court level, Grady's school wins and the court grants their motion for summary judgment based on this idea of primary assumption of risk.
Okay.
So the court felt that Grady, the baseball player, he had done these drills before. He knew the risks of, the potential dangers of people throwing balls around.
Yeah, he signed that form.
He signed that form. During that drill, he had also seen another student get struck in the leg and apparently talked to his teammates about how dangerous the drill could be.
Oh, really?
So he very, very much knew that this was dangerous, right?
Yeah.
And so because he knew that and he participated anyway, that relieved the school of liability. And so the school wins summary judgment and that ends up getting affirmed on appeal. Of course, it ends up getting to the highest court in New York, which we'll talk about here in a second. But for JK, the basketball player, the trial court actually denied the school's motion for summary judgment because the trial court thought that there were still material factual issues based on those dueling expert opinions. So the trial court wouldn't have granted summary judgment because they said, look, this is a question of fact for the jury about whether or not this was an unreasonable risk.
Okay.
I've got these two experts.
Yeah.
I can't pick a side. That's for the trier of fact.
Okay.
But school appeals that. It gets to the appellate court and the appellate court says, nope, the school's motion to dismiss should have been granted because just like Grady, JK knew about the risks. He knew the bleachers were there. They were an obvious and known hazard. So therefore, the school should have prevailed on summary judgment because of the defense of primary assumption of risk.
Okay. I see where all this is going.
Yeah.
Yeah. So they appealed this to the Supreme Court of New York?
Well, no, they didn't appeal it to the Supreme Court of New York. They appealed it to the Court of Appeals for New York.
I thought we were just in the Court of Appeals, Chris.
Don't make me explain. New York's okay. New York is weird. So their highest court is called, we typically call the highest court the Supreme Court, right? Like that's the one at the top.
It's supreme.
It's supreme.
Yes,
yeah, exactly. Right?
Yeah.
But New York's highest court is actually called the Court of Appeals.
Well, this is unfortunately confusing.
Yeah, right?
Yeah.
Well, here, it gets better. They're intermediary courts, so the courts in the middle, the ones that you appeal to.
Yeah, which are normally the ones called the courts of appeals.
Yeah, we call them appellate courts, we call them circuit courts, district courts of appeal, whatever we call them, right? But those are called appellate divisions of the Supreme Court.
Are you kidding me?
Nope.
Who did this.
So they call their Supreme Court the Court of Appeals, and they call their appellate courts appellate divisions of the Supreme Court.
But there is no Supreme Court, technically.
No, because the lowest courts include the Supreme Court.
Excuse me? You know what? We told you that our job was to educate and that we would explain this situation to you. But this is just ridiculous. So why don't we just move on?
Yeah. So their trial courts, or one of their trial courts, is called the Supreme Court.
Great.
So
you know what? If this is really interesting to you, listener out there, the one listener, look it up.
Yeah. No. So anywho, all that to say is we are now at the highest court of New York.
Let's go with that.
And so both students have lost at this point because both schools won summary judgment. And there are kind of two big arguments at the Court of Appeals. The first is whether or not New York law at all should even keep the defense of primary assumption of risk. It's complicated because it deals with kind of New York's shift from a contributory fault regime to a comparative fault regime. That's just kind of a fancy way of talking about how tort law apportions responsibility. So in a contributory regime, plaintiffs can't recover if they're in any way at fault for their injury. So if they bear any responsibility for their injury, they don't win. But in a comparative fault regime, it apportions responsibility based on how at fault each party is for the injury.
Oh, okay. So like our scalpels case, for example, when we had that discussion about, well, there's 75%.
Yeah, 80-20, right?
80-20 or whatever it was responsible. That's a comparative fault regime. Whereas in a contributory fault regime, if they bear any responsibility whatsoever, they bear 100%.
Yep.
Okay.
Do not pass go, do not collect $200.
Got it. And so which one is New York again?
So New York at some point switched from a contributory regime to a comparative regime.
Okay.
And when they switched, typically what happens in a comparative regime is you're apportioning based on responsibility. And one of the things that tells you how responsible a party is this idea of assumption of risk.
Mm-hmm.
And so many comparative regimes will fold in assumption of risk into that comparison of fault rather than keep it as a separate defense.
Mm-hmm.
But New York kept the primary assumption of risk doctrine, which only applies in New York to sporting events. And so they kept that alive, even though they switched. So basically the big argument here is whether or not they should keep it still based on the transition from one view to the other. And the majority says, yeah, no, we're going to keep it. Like, there's no reason not to keep it. And we don't think the arguments are strong enough to get rid of it because we've been doing it like this for decades.
Okay.
And so they decide they're going to keep this defense of primary assumption of risk, in part because of the enormous social value of athletics. And they want to make sure that people engaged in athletics, like basically you don't want too much liability for people who put on athletic events or athletic teams.
Yeah, you don't want to make it so that the school says, you know what, we're not just going to do.
Right.
Because if there's no assumption of risk, if we can't have you sign these waivers and we're always going to be on the hook and liable for any injury that's caused, then we might not even do athletics.
Right. Exactly.
Right.
Yep.
Yeah. Okay. All right.
Yeah. So they keep it intact, right? But the second question is, how does it apply to our cases?
Okay.
So according to the New York highest court, primary assumption of risk applies when, quote, a consenting participant in a qualified activity is aware of the risks, has an appreciation of the nature of the risks, and voluntarily assumes the risks.
Okay, that makes sense.
But a participant is not, however, deemed to have assumed risks that are concealed or unnecessarily enhanced.
Okay, that also makes sense.
It does. I love rules.
I mean, there's
that
a lot of
very
subjectivity
simple.
in there. But,
that's exactly it, right?
As there always is with all of this stuff. But like it, on its face, all of that stuff sounds perfectly reasonable.
Right. Yeah. The question is just like, what happens when the rubber meets the road, right?
Exactly.
Like, how do you define appreciation of the risks?
Because there's a lot of nuance in facts of all of these situations. Yeah.
Right. And a lot of this hinges on whether or not the risks here for JK and Grady were unreasonably enhanced or if they were just like risks that are inherent in the activity itself.
Yeah.
Right. And so for JK, the court looks at this and says, you know what? Running into something that you can see near a basketball court is just part of playing basketball.
Yeah. That doesn't bother me a ton right now.
It doesn't bother me a ton until you add in the fact that they got rid of the out of bounds lines, because running into something on a basketball court, sure, like totally, if you can see it, like that makes perfect sense. But if you're allowed to play all the way up off the court, now it becomes like.
But see, to me, I hear you, but to me, it's the other way around. It's the other thing. See, because I've seen some basketball games. People sit in regular gameplay. People are located, cameras, all kinds of stuff right up till that line. And I've seen lots of players get pushed or jump into, or, they have so much momentum or whatever, they end up going out of bounds and hitting something.
Yeah.
Right?
Right.
So to me, it's the other piece about the getting rid of the
allowing some fouls.
Allowing fouls. But
Yeah.
that's only a potential caution to me, because I don't know the game well enough to know which fouls were allowable and which ones weren't. But that to me is potentially more of the problematic area than the out of bounds things, at least for me, my perspective, my expert athletic opinion.
Well, hey, you said you watched a lot of basketball, so I'm here for it.
No, a lot is relative.
Yeah. Oh, well, yeah. But I mean, your argument is exactly what the Supreme Court says.
Oh,
so,
okay.
They said that the drill did, quote, not unreasonably increase the inherent risk of playing basketball because the risk of collision with an open and obvious item near a basketball court was inherent in playing on that court.
Look at that.
So, Jamie, you nailed it.
Great minds think alike.
Yeah.
Mm-hmm.
Hey, there you go. You think at least like some majority of the New York Court of Appeals.
Yeah. Yeah.
I almost said Supreme Court. Caught myself.
Yeah, don't confuse our listeners.
Yeah. So the court affirms summary judgment for the school in JK's case. So JK's case is done.
Okay. What about Grady?
What about Grady?
Yeah.
Grady's a different story. The court looks at the situation and ultimately decides that there are questions of fact here that preclude summary judgment. So they say that it was wrong to grant summary judgment for the school here because there's a question about whether or not the drill with the use of the 7 foot by 7 foot screen between the two first basemen created a, quote, a dangerous condition over and above the usual dangers that are inherent in baseball.
Okay.
Right. So that's the big question. Like the Supreme Court seems to think like, hey, you know what? There's a potential issue here where maybe that is an unreasonable risk. We can't say as a matter of law that that's not an unreasonable risk.
Yeah.
Because, usually in baseball, we talked about this already. There's only one ball, not multiple balls. They're not all being thrown to the same part of the field.
Right.
And typically, we don't rely on a small screen to protect players from wild throws.
Right. And the other thing about that screen, too, that I was thinking was, I wonder if that screen created a false sense of security.
Right.
Like, oh, we've got this screen here. We don't have to be as cautious. Right.
Right. Yeah. One point, Grady did say that he knew it was dangerous with or without the screen. And so one of the lower courts actually looked at that and said like, oh, look, he knew it was dangerous even with the screen. So therefore he assumed the risks voluntarily. But another one of the opinions actually said like, hey, they used this screen because it was the biggest one they had, not because it was what was necessary to keep people safe.
Oh, okay.
Yeah. So I think that there's definitely like,
all right. So there's some
the
issues
screen
here.
is playing a lot of, it's doing a lot of work. Obviously it's not working as intended, but it's doing a lot of work in the legal analysis.
Okay. Gotcha.
But yeah, so the court says for Grady's case that errant balls may be an inherent risk of playing baseball, right? Like wild throws are a thing that happens in baseball. Sure.
Yeah.
But a jury should be permitted to determine whether plaintiff's injury was the result of such an inherent risk or whether the risks were concealed or unreasonably enhanced by the complexity of the drill with the use of a small protective screen.
So I got
going back to that language, right? That squishy language.
So that's probably a motion for summary judgment that should have been denied in the court's opinion, right?
Yep. So the court said that summary judgment was inappropriate, should have been denied. So they sent Grady's case back down for further proceedings.
All right.
And so fast forward to January of 2024.
Oh, recently. Yeah.
So which means that this case had been going on for years.
Yeah. normal.
Typical, right?
Yeah.
Especially if you go up all the way up to the highest court and you have a couple of appeals, right? Like these things can take on a life of their own. So it goes to trial in January of 2024. And on day 6 of the trial, the parties settle.
They've spent 6 days hearing arguments.
Right.
And like probably expert witnesses and, you know, and all that stuff. And then they're like, oh, this could get messy.
Basically, both of them got cold feet and they're like, ooh, I don't feel confident about winning this thing. Let's see if we can meet in the middle.
That's so fascinating.
Yeah. But yeah, imagine like this has been going on for years, right? You've been litigating this case for years.
Yeah.
You've done discovery. You've done motions. You've done all this stuff. You've sat a jury. You've put on 6 days of testimony for the jurors.
Yeah.
You've got your exhibits, your witnesses, all that stuff. And then like...
That's a lot of investment.
It is. But it's better than rolling the dice with a jury, right? Like, these parties seem to think so.
That's why people settle. They're like,
exactly. So it settled on day 6 of the trial, and I wasn't able to find any information about the settlement.
Oh.
I know. So at least, you know, hopefully Grady got something for that injury, right?
We need to hire some paralegals on this show, huh?
Private investigators?
Some PIs?
Yeah.
All right. So, that's, you know, it's also interesting. Like, you know, so the big takeaways here are, I'm just thinking as a school administrator, like I was always nervous about I remember going down, man, I was a middle school principal and we had lots of athletics going on. And I remember going down and watching these basketball games and, you know, how physical they were, even at the middle school level. And I mean, I've dealt with a number of student injuries as a result of gameplay and things like that. I mean, I would say none of them ended up in a lawsuit, you know, but I probably can't count on 2 hands the number of times I had in my career a student come to school the next day with an injury that they sustained at one of the athletic events, right?
Yeah. Yeah. It happens.
It happens all the time. Mm-hmm. And so, you know, as a school, you know, I think if we're going to provide any sort of advice here, it's like, just remember, be careful, be reasonable. It's good to get creative and try to spice things up a little bit to exercise kids' skill set and things like that. But like, don't get so creative that it crosses the line into something that adds an unreasonable degree of risk where there doesn't need to be.
Right.
Right?
Yeah. And I think that's a great takeaway because both of these drills, like the further they got from the normal rules of the game, the harder it is to justify the potential enhanced risk, right? So like not having boundary lines in basketball and allowing some lighter fouls, like, you know, you switched up the rules a little bit, but not a substantial change. Baseball, like now you've kind of like, you're adding 2 balls and having basically 2 plays going on at the same time. Now that is a very, very different game.
Yeah.
Right.
Yeah.
And so the further you get from the established rules and expectations, the more likely it is that you've now created some unnecessary or enhanced risks.
Yeah. Yeah.
And, you know, the other thing, like, you know, I love the advice of be reasonable, right? Like, but that should be also comforting too, right? Like this idea that, you know, you as a school aren't always going to be responsible, right? Like as long as you're doing what you needed to do to prevent foreseeable injuries, and if you're not creating enhanced risk, like you're on good legal footing, potentially, right? Like depending on the circumstances and the context, right? But like, you know, that should help some folks hopefully breathe a little easier.
Yeah.
But yeah, the enhanced risk thing I think is crucial here.
Yeah. No, I agree. That, you know, be reasonable. Don't take it too far. And if that's the case, you should be mostly in good shape, right?
Well, at least 50% of the cases we talked about today were.
Yeah, exactly. All right, so there you have it. Chris, what's our homework?
Your homework is to dodge, dip, dive, duck, and dodge.
the 5 Ds of dodgeball. If you can dodge a wrench, you can dodge a ball.
I've been thinking about that quote, thinking about like, you know, the normal rules and expectations. Throwing wrenches is probably not a reasonable deviation from the rules of dodgeball.
Right? Right.
But keep your head on a swivel and go to chalkandgavel.com. You can find our teaching guide there. Find us on social media at Chalk and Gavel. Like, rate, review. We would love to hear from you. Continue the conversation. Support us on Patreon. Your support means the absolute world to us as we continue to sustain this show into its second year.
All right, folks. Well, that does it for this episode of Chalk and Gavel, and we hope to see you, or we hope you tune in a couple of weeks to listen to the next one. So we'll see you then.